Dear children, today we have to learn in Standard 9, Subject Social Science, Chapter number 11. The name of the chapter is Indian Judiciary. Now, already we have to learn about the High Court of the Gujarat. Now, our next topic is subordinate courts. What is our next topic? The next topic is subordinate courts. Under the guidance and the supervision of the High Court of any state, there are the district and taluka court. Dear children, in first lecture already I am draw the pyramid of the court, and we know very well that the guidance as well as the supervision of the High Court of any state, there are the district and taluka court is there, fast track court is there, quota court, tribunal, and certain special courts are working. Each state is divided into an administrative unit called district, consisting of civil code, criminal code, and revenue code. What they have to say that, dear children, they have to say that every state was divided into an administrative unit, and this administrative unit called the district consists of the civil code, criminal code, as well as the revenue code. After, dear children, they have to given about the district judge. What they have to given? They have to given about the district judge. District, it means city. Judge, it means Nyayadhish. The appointment and the promotion of any individual to the post of the district judge is done by the governor of the respective state. What they have to given, the dear children, in the district judge? The district judge was appointed as well as the promotion of any individual to the post of district judge is done by the governor of the respective state in the consultation with the High Court of the state. What happened there? Here the governor has respective state in consultation with the High Court of their state. After, dear children, they have to given about the information of the qualification of the district judge. Now, qualification, it means laikat. A person being appointed as a district judge should be a citizen of India. What was the first condition for the qualification of the district judge, dear children? The condition of the district judge qualification is that should be a citizen of India, should possess a practice as an advocate for the last 7 years. For the how many years they were possessed for the practice? They were possessed for the practice as an advocate for the last 7 years. An officer in the judiciary of either the state or the central government too is eligible to be appointed as a judge of the district court. Now, who is appointed as a judge of the district court? Any officer in the judiciary, either of the state level or the central level government, is eligible to appoint as a judge of the district court. All the other judges other than the district judge are appointed by the governor. Dear children, be careful. What they have to say there? They have to say that all the other judges other than the district judge are appointed as judges are appointed by the governor or the High Court with the consultation with the State Public Service Commission in accordance with the rules framed by the Constitution. The judge who handles the civil suit is called a district judge. What they have given about the district judge? A district judge, it means a judge who handles the civil matters is called as a district judge, and the judge who handles the criminal cases is called the session judge. What they have to given? They have to given about the two judges. One is the district judges, second one they have to say about the session judges. In session judges, they have to handle the criminal cases is called as a session judges, while in the district judges they have to handle the civil cases is called as a district judges. A district court, here the petition challenging the judgment of the lower court under it. What they have to say there? They have to say that a district court, here the petitioner regarding with the challenging the judgment of the lower court under it. All the civil suit of the rupees 1 lakh or more, either by the government or against the government, are carried out in the district civil court. What they have to say there? They have to say that all the civil suit of rupees 1 lakh or more than 1 lakh, either by the government or against the government, are carried out in the district civil court. The judge of the district court has the power to run the case of the marriage, divorce, alimony, reform and the cases of the parental custody. What they have to say that? They have to say that the judges of the district court has the power to run the cases. And which kind of the cases they have to run? They have to run the cases like marriage, divorce, alimony, reform and the cases of the parental custody. The criminal court include the session court and the first class judicial magistrate court, second class judicial magistrate court, Mamlatdar and executive magistrate court. What happened there? Here in the criminal court, they have to include the session court, first class judicial magistrate court, second class judicial magistrate court and the Mamlatdar and executive magistrate court. This court have a power to given the punishment of the imprisonment and ragging from 3 to 10 years. How much they have given the punishment? They have given the power to given the punishment of the imprisonment. Imprisonment means it's jail, and they also ragging from 3 to 10 years and a penalty up to rupees 5,000 or more than 5,000 rupees is there. In case of the murder, the court give the capital punishment and the lifetime imprisonment and the life sentence. What happened there? In the case of the murder, the court has authority and power. They have to give the capital punishment, otherwise they give the lifetime imprisonment, otherwise life sentence. These three kind of the punishment they have to given them. Apart from this, in a district there are the small case of the court and the family court also there. For the case of pertaining to the land revenue, there is a revenue court. What happened there? If is there any case pertaining with the land revenue, and this is concerned with the revenue court, and for the dispute of the laborer, there is a labor court. If is there any dispute between the labor, then there is a labor court along with the other tribunals. As per the example of the tribunal for compensating the vehicle accident, for the protection of the service and other rights of the teachers and the professors, there is a Gujarat Educational Organizational Service Tribunal. What happened there? Here there is a protection of service and the other rights for the teachers as well as the professors, and there is a Gujarat Educational Organization Service Tribunal. Tribunal for recovering the debt, for the protection of the consumer rights, and the Consumer Rights Protection Forum are the working for that to provide the consumer as providing their rights. This tribunal functions like a court and held the cases where the petitioner recover their losses and receive the compensation. What happened there? Here the tribunal function like court and held the cases for the petitioner to recover their loss and receive the compensation. Each district there is a fast track court. What happened there? Here each district you have to find the one fast track court with an objective to run the fast cases. For hearing the cases of quota, there are the quotas courts in the Gujarat. All these courts have gathered important by decentralizing their administrative and function independently. What happened that here all these courts have gathered for the important for the declaration of their administration as well as they are doing their function independently, firmly and lawfully. People have started taking all the benefits, have become the aware. Now what happened that here the people have required for the awareness for starting and taking all the benefit, have become the aware. After they have given about the information of the Lok Adalat. It means Lok Adalat. Gujarat state is the first to start the Lok Adalat. Which state is the first to start the Lok Adalat? The Gujarat state is the first to start the Lok Adalat and provide the speedy as well as the economical justice to the poor, weak and exploited section of the society. Why the Lok Adalat has been started? Because the Lok Adalat provide the speedy and economical justice to the poor, weaker and exploited section of the society. Under this code, they have to provide free support and the guidance through the Legal Aid Service Center. What happened that under this Lok Adalat code, they provide free support and the guidance through the Legal Aid Service Center situated in Ahmedabad. Local Adalat function voluntary even on Sunday and the holiday. What happened there? Here be careful and remember. Lok Adalat given their function of the work voluntary even on Sunday as well as the holiday at the district and the taluka headquarters as per the convenience of the petitioner. The Lok Adalat generally hear the cases of the accident is related with the compensation, divorce, alumni, general debt, personal complaint, police complaint. Which kind of the cases are to be the solved by the Lok Adalat? Then Lok Adalat generally hear and the solve the cases of the accident related compensation, divorce, almighty, general debt, personal complaint, police complaint. Lok Adalat consists of advocate, social worker, educationist, reputed citizen, businessman, police officer, insurance officer, judges and judicial official. Now which person are connected with the Lok Adalat? In Lok Adalat are consist with the advocate, social worker, educationist, reputed citizen, businessman, police officer, insurance officer, judges and the judicial officers. Here the cases are settled and such that both the parties are to be the satisfied. That way they have to solve the cases by the Lok Adalat, that both the parties are to be satisfied. The cases fought in the Lok Adalat are neither win nor the losses. Lok Adalat save the time and the money. Main function of the Lok Adalat is to save the money as well as the time of the people. Many pending cases are to be solved by the Lok Adalat. All the judgment of the Lok Adalat are backed by the law. Therefore, the Lok Adalat have become a center of the attraction, and that's why we can say that the Lok Adalat have become the center of the attraction for the people to solve their dispute. Next one, they have given about the independence of the judiciary, Nyayatantrani Swatantrata. The Indian Constitution has kept the judiciary independent, firm and fearless from the legislative and the executive for the protection of the fundamental rights. Already, dear children, we have learned three functions of the government. Which are three functions? In these three functions, one is a legislative, second one is a judiciary, and third one is the executive. Legislative and executive are working, but the judiciaries are independent. They are also the working. That's why they have to say that Indian Constitution has kept the judiciary as the independent, firm as well as the fearless from the legislative and executive for the protection of the fundamental rights of the citizen, for social, political and economical equality and for providing the justice. What happened that why the independence of the judiciary? Because they protect the fundamental rights of the citizen, also for the social, political and economical equality and provide the justice. The judiciary should not be inclined or biased towards the government. The term and the condition for the appointment of the judge, appointment process, pay scale, transfer, promotion and retirement etc. is taken care by the executive as per the constitutional provision. What they have to given the dear children? They have to given the term as well as the condition of the appointment of the judges, appointment process, pay scale, transfer, promotion and retirement is taken care by the executive as per the constitutional provision law. The judge are appointed for the specific period of the time. The executive cannot remove any of the judge due to their will or any political pressure. Be careful and remember. What happened? The executive cannot remove any judge due to their will or any political pressure. The pay scale and the term of the service, transfer, promotion, benefit of promotion, pension fund of the judge cannot be altered. During the term of the service of the judges, any of their behavior or their judgment cannot be discussed or critically reviewed in the parliament or the legislative assembly. What happened there? Here they have given that during the term of the service of the judge, any of their behavior or their judgment cannot be discussed or criticized and reviewed in the parliament or the legislative assembly. The judge after the retirement cannot carry out their practice in any of the court. What they have given there? They have given the judge after the retirement cannot carry out their practices any court. The purpose is to empower the judges to perform their duty fearlessly, honestly, self-reliantly, independently and firmly, so that the judge can impart the true, transparent and the quick justice. What was the main power and the purpose to given the authority and power for the judges? The main purpose is to empower the judges to perform their duty fearlessly, honestly, self-reliantly, independently, firmly, so that judges cannot impart the true, transparent and given the quick justice. The Indian Constitution has given the judiciary independent, impartial and uniform place. And that's why we can say that the Indian Constitution has given the judiciary an independent, impartial and uniform place. The cases of the public welfare, the question of the public welfare or important problem pertaining to the public welfare can be written on a simple postcard or an ordinary letter to the Supreme Court. What they have to given? They have to given that any cases of the public welfare or question of the public welfare or important problem pertaining to the public welfare can be written on the simple postcard or on ordinary letter to the Supreme Court. In the past, the Supreme Court has treated such matter as a petitioner has given the trend-setting judgment. This has proved the vigilance of the judiciary in the public. Now, dear children, they have given about the fact of the India. At the present day, there are near about 3.5 crore pending cases in our judiciary. How much? Near about 3.5 crore pending cases in our judiciary. And second, insufficient number of the court judges and the staff is the reason in the delay in the justice. Why we can say that delay in the justice into the India? Because there is a insufficient number of the court judges as well as the staff. That's why the delay in the justice. This is the main reason. The present central government has undertaken the task for the reframing 1,500 old and irrelevant law. Thank you, dear children.